Okay, well, let's go ahead and get started. Good afternoon, everyone, and thank you for joining us this Saturday afternoon. I am Monica Crooms Mkhikian, and I am an immigration attorney with U.S. Immigration Law Group. U.S. Immigration Law Group is an immigration law firm based in Santa Ana, California, and the focus of our practice is everything related to immigration law. We provide a wide array of services, which includes everything from DACA, family-based petitions, naturalization, to non-immigrant visas that include tourist visas, work visas, and removal defense. And so I'm excited to be here with you all today to provide this presentation on sort of the current state of affairs with immigration law, and to offer this presentation entitled DACA, TPS, and Immigration in 2021. Let me get the slideshow started. Okay. Okay. Okay, so we'll start with the current state of DACA, and we'll talk about what's happening in the way of reform, or not reform, excuse me, regulation, what the Department of Homeland Security is currently processing, what applications, who can apply, and how to apply. So fortunately for us, currently USCIS is processing all DACA applications under the requirements of the program as it was set out initially in 2012. This means that DACA recipients may file renewal applications, those who have DACA currently, but also applicants who are applying for the first time can also submit applications. With the submission of a DACA application, with the submission of a DACA application, DACA recipients will get a work permit and employment authorization document that enables them to work in the United States. And that employment authorization document will be valid for a 2-year period. Anyone who filed a DACA application or renewal previously or in 2020 and was issued an employment authorization document for only a year validity will actually be able, or will automatically receive an extension from 1 year to 2 years. So if your DACA employment authorization document is only valid for 1 year, do not be stressed about that. You don't have to apply again this year. Your EAD will be extended for that 2-year period. Also, not a new factor, but a new to 2021 factor is that anyone who has a valid DACA employment authorization document is also now able to file an application for advanced parole. So advanced parole permits someone to travel internationally, so outside of the United States for reasons related to a humanitarian need, and a need to travel for employment, as well as a need to travel in connection to education. So again, those three underlying reasons for which a DACA recipient may request to travel or permission to travel abroad is for humanitarian purposes, work purposes, and education purposes. Some examples would be, an employment, or excuse me, a conference related to the work that you do abroad, or study abroad if you're a student. And also with respect to the humanitarian purpose, the fact that you haven't seen specific relatives for perhaps decades or years and they're living abroad, that may be a reason to be able to visit family you've not seen in quite some time. And then also, I think slightly more compelling would be if any relatives who are living abroad are currently experiencing health issues that require hospitalization, or just that, we have left them in a delicate state of health. And perhaps you're concerned that if you're not able to travel to see those relatives now, perhaps you might not have that opportunity if they were to become, so sick that they would pass away. So those are the three bases for applying for the advanced parole document, which again would allow you to travel internationally. Now, what are some of the benefits of traveling internationally if you have DACA? Well, depending on the circumstances, but in most cases, our DACA recipients, entered the United States either without status or without a visa, or maybe they entered with a visa, but they're now currently out of status. And in the event that they become eligible to, well, rather in the event that they have a petition filed for them, so maybe they get married, maybe they have a child who files a petition for alien relative on their behalf. If that person traveled with advance parole and re-entered the United States with admission, that may possibly open up an avenue for them to apply for adjustment of status in the United States, meaning that they could apply to get their green card in the United States and not have to leave the United States in the future to visit a US consulate to get that green card. So that, that specific opportunity is heavily dependent on all of the facts and circumstances in an individual's case. And so we highly recommend that anyone who's, thinking about applying for adjustment of status, who is in DACA status, absolutely talk to someone who is either an immigration lawyer or a DOJ approved or appointed representative, so that you can be sure that you actually qualify to file the application under the law as it applies to that specific individual. Okay, so who qualifies for DACA? We know that anyone who would like to seek DACA needed to have entered the United States before they were age 16. So 15 or younger at the time they entered the United States. Anyone who entered at age 16 or older, unfortunately, is not eligible to apply for DACA. The individual needed to have been present in the United States on June 15, 2012. And that is an important date for DHS when they're considering DACA applications. They are requiring that the applicants have documentation that shows specifically that they were in the United States on or around June 15, 2012. So to the extent possible, I think it's really important, if you have any documents that would prove your physical presence June 15, 2012, then, protect those documents, scan them, save them somewhere so that where you can locate that document or those documents at the time that you're ready to file your DACA application. The person needs to have, or the individual who's applying for DACA needs to show that they continuously resided in the US for at least 5 years prior to June 15, 2012. So that would put us at June 15, 2007. So it's important that you do everything in your power to find as many documents as you can to establish that physical presence. We have many clients who ask us if just filing taxes is enough, or just submitting their taxes is enough, or documents for a few months rather than several months, or all of the months of any given year. And our response is always going to be, the more that you can provide in the way of documents, the more substantive your application is going to be, and the more higher the likelihood that the officer will determine that you did satisfy that continuous physical presence requirement. And so what I would say is, get creative. Do everything you can to find the documents that you think establish your physical presence. So what does that mean? We're talking school attendance records. We're talking medical records, dental records. Yes, your parents' tax return, if you were included as a dependent on your parents' tax return. If you had social media in those years, 2007 and later, then perhaps printouts of specific dates in your social media, from your social media profiles will be useful. Letters that were addressed to you and dated, photographs even that have dates on them. Anything that essentially has a date on it with that is addressed to you, or that includes a photo of you, will be a valid document to establish physical presence. Our recommendation is at least one document for every 2 months. But we've had applications approved with less than that, because we know 13 years is a long time to be saving paperwork. And, some of us don't save the paperwork for that long, but it is incredibly important for immigration that if you are someone who is not currently in status, keep everything, keep all of your paperwork. And if you don't want to keep physical paperwork, scan it, because it will be important. I can almost guarantee that it will be important at some point in the future. You also need to show that you are either currently in school, you graduated from high school or obtained a GED, or you were honorably discharged from the military. If you did not graduate high school and you don't have your GED and you are not honorably discharged from the military, then you can go ahead and enroll. If you're not currently in school, there's nothing that prevents you from enrolling into a GED program or a high school diploma program. And as long as you can establish that you're currently in school, then you're eligible to apply for a new application for DACA. You also should not, or you also cannot have been convicted of a felony or serious multiple misdemeanors. So, sorry, I kind of conflated those two. So you cannot be convicted of a felony, and you cannot be convicted of a serious misdemeanor or multiple misdemeanors. Multiple is 3 or more. Depending on, if you do have a misdemeanor conviction or maybe 2 misdemeanor convictions, I absolutely recommend that you consult with an attorney to determine whether or not those will interfere or will prevent you from being granted, your DACA status. Because in the event that an officer denies DACA status based on convictions, then DHS may potentially refer that individual to immigration deportation proceedings. So to avoid any issues in the future with having to do with removal proceedings, absolutely consult with an immigration lawyer if you have been arrested, charged, or convicted of any misdemeanors or any felonies. Now, the fact that you have been convicted does not necessarily does not prevent someone from applying for DACA necessarily in the event that they're able to perhaps get that conviction vacated, or they can do some kind of post-conviction relief to remove that conviction from their record. There are a number of ways that can be done, but again, I think that's a little more advanced. It's too advanced for what this presentation seeks to provide, but absolutely something that you should keep in mind and bring to the attention of an immigration attorney so that you can determine whether or not you'll have a shot of applying in the future. And chances are, if you do have, some kind of conviction and there is a possibility to adjust status in the future or to legalize in the future, you're going to need to address those criminal issues anyway. And so absolutely, I think it's in anyone's best interest to consult with an immigration attorney if they do have any convictions. Okay, and then lastly, the applicant must have been born after June 15th, 1981, and they have to be over 15. So if you were born anytime before June 15th, 1981, unfortunately, you're not going to be able to apply for DACA. I don't know, at this point, we know that there's lots of talk, there's lots of buzz surrounding the issue of DACA and whether or not there's going to be a reform, whether or not Congress is going to expand the program, or if President Biden is going to expand the program. And, there's always a possibility, but today the law is, we're presenting to you the program as it is guided under the executive order that was issued by President Obama. And so DACA is not actually a law. So I do correct myself there. It is it's a program established under executive order. And so currently we are only able to apply under the requirements that were issued in the executive order in 2012. Now, if there are any changes that should happen in the future, then absolutely, if you hear about them, contact us, call our office and ask, if you become eligible under the new rules or under the new program, should it become available in the future. Okay, so what kinds of documents do you need to submit with an application for DACA? The most important document is going to be your birth certificate. Your birth certificate establishes your identity, where you were born, and then also a copy of any government issued identification. And so that could be a passport, a consular ID, it could be a driver's license if you have a driver's license. You also will need to include 2 passport-sized photos with your application packet, and also a copy of your high school diploma, your GED, or proof of your current enrollment in school. Documentation establishing your presence in the US, as we discussed, beginning June 15th, 2007, all the way through today, all the way through now, which is March. Today is March 6, 2021, but you want to have documents that span the time of June 15, 2007 until the present. So we're talking 13 years of documents. Well, 13, almost 14 years of documents. You also need to have so if you do have any criminal convictions, you want to provide copies of your certified criminal records. You can request those from the court where your case was processed. And then also the payment to the Department of Homeland Security is $495. And you can submit the payment for your DACA application using a check or money order made out to the Department of Homeland Security. And then depending on whether or not you file your application on your own or you hire someone, be it an attorney or an accredited representative to help you file your application, you may incur costs, legal fees or preparation fees by the person who's assisting you with preparation. Okay, and with that, we transition to temporary protected status, but I want to see if anyone has any questions. So if you have any questions about what we've covered so far, please feel free to go ahead and type in your questions. And I'm just going to check. I'm struggling with technology today. Let's see. Okay, looks like we're good. I don't see any questions. No. Okay, so moving on to temporary protected status. Okay, so on December 9th, 2020, DHS automatically extended the validity of TPS for people who were either, well, so we have two groups here. So the first one is countries who were extended to October 4th of this year, 2021. So that includes El Salvador, Haiti, Honduras, Nepal, Nicaragua, and Sudan. The following countries are due to expire not October 4th, 2021, but so we have the closest, which is Syria, which is at the end of this month, March 31st, 2021. I checked today, I still haven't seen any kind of update as to any extensions on Syria, but then we also have Somalia, September 17, South Sudan, May 2nd of next year, 2022, and Yemen, which is September 3rd of this year. So TPS holders are individuals who are nationals of countries that have specifically been identified by the Department of Homeland Security as countries that have suffered some kind of catastrophic event, some kind of crisis that warranted an emergency protected status to nationals from that country. So individuals who are in the United States who qualify for temporary protected status are given an employment authorization card so that they can remain in the United States and work with lawful authorization. TPS holders with an employment authorization document that is due to expire at the, on April 2nd, or so who that already expired. So that expired April 2nd, 2019, January 2nd, 2020, March 24th, 2020, and January 2nd, 2021 are all covered by an automatic extension. Eligible TPS holders do not need to pay a fee or file an application to receive the automatic extension. It's automatic, it's fine as long as they have their EAD, even if it has an expired date on it, it still authorizes them for employment. And TPS holders who did not re-register during one of the above registration periods can still file a late re-registration application if they can show that they have good cause for not filing on time. Again, so if you have an employment authorization document that's already expired and you presented that to your employer and your employer is not sure whether or not that's a valid document, you can present the EAD or your receipt notice, your notice of action, and a copy of the Federal Register notice that you can get online to show that you have an automatic extension. Okay. And now we're going to transition into something that is a really hot topic, and it's immigration fraud. So currently, as I said earlier, there's just a lot of talk about updates in immigration, possible changes in the law, the Biden administration has presented the Citizenship Act of 2021 about 2 weeks ago, a little over 2 weeks ago. And so there's so many questions about what we can expect, what is actually happening, what changes will actually go into effect. And unfortunately, we don't know those answers yet. I wish I had a crystal ball and I wish I could say or tell you today exactly what we should expect, but we don't know. However, there are lots of people, organizations, groups, individuals who take advantage of the hope that people have, the hype around, the talk of a reform to defraud people. And, we know of several organizations, several people already who have said, yes, I've talked to, someone that I heard an ad for on the radio. I called and they told me I could start my application now. What application? There is no application under the current Biden administration or under the Citizenship Act of 2021 that's been created that allows anyone to apply for legalization. Not yet. We don't know when that will happen. Our office is always abreast of all of the newest changes and any news or reporting on what is coming out of Congress. And we know that the House already has said that they're not going to vote on the reform just yet. They're still waiting to determine if they're going to vote on it as an entire bill or maybe as a bill that's been broken up into different pieces or different parts, and then consider those specific parts individually. So with that, what are the things that you should be thinking about or looking for when detecting or considering whether or not you have fallen or are being subject to immigration fraud? The first thing is, if you go to an office and someone tells you you should sign a document that's blank, that you have not filled out, you have not reviewed, that is a huge red flag. I would just get up and walk out. I would not sign anything that's not complete, that you haven't reviewed. Don't sign a contract that you don't understand. Make sure the contract is clear and make sure that the person can actually explain to you what it is that you're signing. Always ask for a written contract, and then always ask for a copy of your signed contract as well. If the individual does not have a contract for you to sign, then there's no way for you to enforce, there's no way you can enforce anything against them. If they do, end up, if they do subject you to some kind of immigration fraud and you end up needing to file a report or a police report, it's important to have evidence of the actual relationship that you established with them, of the money that you were charged. So if you can, to the extent that if they're not going to offer you a contract, I would walk out. I would find someone else. Be aware of individuals who want you to pay everything up front. If you pay everything up front, then there is less incentive to complete your applications on time. Also, request copies of all of the documents that you've submitted, and never leave original documents in anyone's office. Our office never keeps original documents because there's no need. Immigration accepts everything as photocopies. And so the only time that our clients are required to have original documents is if they are taking them to an immigration interview. And so at that point, the officer will review the originals, but you never submit those to immigration by mail. And also ask for a receipt every time you make a payment. Ask for a receipt of how much you paid, so that in the event that you should have to report that individual to the bar association or to authorities, you have evidence of the money that was paid. And unfortunately, in many of these instances, and many of the instances of immigration fraud that we've seen, individuals don't have proof of money paid, and so they can't establish how much money they actually lost. And don't hire anyone who cannot answer your questions. It's important that you feel confident in that person's ability, and if they can't answer your questions, chances are they don't know what they're talking about. So if they can't answer your questions, get out of there. And what do you do, or what can you do if you think you've been a victim of immigration fraud? First, you can call the California State Bar or the State Bar Association in any country, in any state, and report the office or the person who subjected you to immigration fraud. Second, you can contact local police. You can contact the Attorney General's office, and you can contact the DA's office, the District Attorney's office. I think the most effective the most effective thing to do is to contact the Bar Association. We know, I mean, I can certainly say that in California, the Bar Association does take immigration fraud very seriously. And I've helped clients file reports of immigration fraud, and the Bar has actually done something to help recover the person's documents and, recover their money. Okay, so what's the difference between an immigration consultant and an immigration lawyer? So an immigration consultant is allowed to fill out forms, they can translate documents, they can obtain and submit documents for you, and they can help you find legal representation. But they cannot give you legal advice. They cannot tell you, what you're eligible for under the law. They cannot tell you what you, essentially, they can't tell you what you're not eligible for under the law or what you are eligible for under the law. They can't give you legal advice. They can only fill out forms for you. And we know that individuals who are not attorneys, they don't always follow that rule of thumb. And so they give legal advice, they tell people what they can and cannot do, and sometimes they're wrong. And they cannot represent you in court either. Okay, so what to expect in 2021. Before I move on to this last sort of part of the presentation, I just want to see if we have any questions. Let me just check. Oops. Okay, I don't see questions. No one has raised their hand. Okay, so the next part of the presentation really has to do with the Citizenship Act of 2021 and what the Biden-Harris administration has already started doing with respect to immigration since day one, since Inauguration Day. So immediately we saw the Biden-Harris administration lift the travel ban and the Muslim ban. There are still some restrictions, COVID-related restrictions. For example, individuals traveling from the Schengen countries, so several European countries, are not able to travel to the United States currently unless they fall within an exception. So like if you have a tourist visa and you're hoping to travel to the United States from Europe, you're not going to be allowed to enter the United States. But if you are a green card holder or a citizen or the child of a citizen, child or spouse of a citizen or a green card holder, then potentially you'll come in as someone who qualifies for a waiver. So I think that if you're going to travel abroad, if you have a green card or you're a citizen, you should be fine. But if not, if you have a visa, then definitely make sure that you read up on what the current restrictions are for the countries where you'll be traveling to. The Biden-Harris administration have already placed several limits on removal enforcement. So immigration actually has, or ICE has now been restricted severely in terms of who they can remove from the country. So potentially it's anyone who poses a threat to national security can be removed, but anyone who was in the country before November of 2000 will not be removed by ICE currently under the Johnson memo. Or not Johnson, excuse me, the Koski memo. So currently, if you are in the United States and you have a removal order and you were in the United States before November of 2000, or if you don't have a removal order, but you are on ICE's radar, you will not, or you should not be removed under the memo in place, with the hope that there will be some sort of, something that can happen that will potentially be a reform or something that will allow the person to stay in the United States with authorization for employment, I guess until just further notice, until we know, what is going to happen in terms of any kind of developments in immigration. We know that once someone is removed from the country, then they are, their opportunities to legalize become severely restricted. So this is big. This is important because I have several clients who, before the Trump administration, although they do have removal orders, there were options for us to get those removal orders reinstated. Those opportunities were restricted by the Trump administration, and hopefully they will be restored now by the Biden-Harris administration. There are priorities that are being set in place. And we know that the Biden-Harris administration has withdrawn the third-party safety agreement for applications for asylum. Also, they've created a task force to reunite children with their parents, and they've halted all new border wall construction. There also, I mean, there's talk about reversing the public charge test that went into effect last February. Currently, the public charge test is still in place, but there is movement to get that reversed and restored back to the previous public charge test that was a lot less cumbersome on applicants for their green card. So before I get into the Be Proactive, there are just a few more points that I want to make about what the Citizenship Act of 2021 actually is, what it proposes, and what we're waiting to see may or may not become a new, incredibly desirable immigration reform, but we are waiting on the edge of our seats. So under the U.S. Citizenship Act of 2021, the bill actually has created or provides for a 6-year status called lawful prospective immigration status, so LPI status. So if you are able to acquire LPI status, then you'll be authorized to work, join the military, travel, and live without fear of deportation. This LPI status potentially will include spouses and children. And after being in LPI status for 5 years, then you'll be able to apply for lawful permanent resident status. So who will be able to apply for LPI status? Essentially, anyone who was physically present in the United States who is undocumented on or before January 1st, 2021. So the bill is really expansive. It provides for the legalization of approximately 11 million people. It's very generous, and it would be an incredible opportunity for individuals who are in the United States currently without status. There are exceptions, or not exceptions, there are actually provisions that would speed up the process for people who have DACA and TPS. And so dreamers, you know what, I'm going to go back and say people with DACA, individuals with DACA, recipients of TPS, and then some other categories will be able to apply for their green cards in a 3-year period. They'll be able to get their green cards right away and then apply for citizenship in a 3-year period. So let me say that again. So if you have DACA, TPS, and then some other categories will also be included. I'm not sure what they are yet, but some others will also be included in this eligibility for immediate green cards under the Citizenship Act of 2021. And then after 3 years, they'll be able to apply for citizenship. The person or the applicants must show that they've been physically present in the United States on or before January 1st. I think I said that already. And let's see. Oh, and then also something that's very important is there will be an increase in the U visa numbers. And so currently the under federal law, there are only 10,000 U visas that can be issued per year. And so there's an insanely long wait list of about 9 to 10 years, I think it is at this point. And so potentially under the Citizenship Act of 2021, also there may be an increase in the U visa numbers that are issued. And so potentially people can get U visas more quickly. I assume that there will be people who don't qualify for LPI status under the act. And I don't know what those qualifications are yet. Should the bill be passed by the Congress and by the Senate, then the regulations need to be formed and published and commented on. And so I don't know what the restrictions will be, but I do assume that there will be grounds of inadmissibility and reasons that people are not eligible. And so that is, to be determined. And there's also going to be a sort of focus on family unity. So under this act, the family-based immigration system is going to change. It's going to, right now, we know that if you are from Mexico and you filed a petition for your sister or your brother or a son or daughter who's over 21, the wait list is insane. It's like 20 plus years. And so we hope to see that there will be some sort of shift in the family-based immigration system that would reduce those wait times substantially. There's talk of possibilities of family members being able to come to the United States and wait in the United States while their applications are processing or while they're waiting in that queue. And let's see, there's going to be reclassification of certain family members as well. Expansion of who an immediate relative is. There's also going to be an expedited path of legalization for certain employment sectors, and that, you know, one of those sectors, which again is a very immigrant heavy sector, which is our farm worker, our agricultural sector, and our farm workers. And there's also going to be some labor protections that are strengthened and increased for high skilled workers as well. So again, I think the take home and what's most important in considering the Citizenship Act of 2021 as having been presented to Congress is that it's not a law yet. There still has not been any change in our immigration laws and our immigration system. Our immigration system continues, you know, as it has been, but we are, you know, we're waiting. We're waiting to see what happens. We're waiting to see if Congress or if the Senate votes on any changes. And it would be, I mean, it would be wonderful if the Citizenship Act of 2021 was voted on and passed in its entirety, but I don't think that's our reality. I don't think that's going to happen. It's just, it's too big, it's too comprehensive, and I think that we are, you know, sort of coming out of a very tense period, a tense 4 years under the prior administration. You know, we've seen in news and the media just sort of the you know, just sort of the divisiveness or how divided our country is. And so I think that it will definitely be a while before we could see an act like this be passed in its entirety. However, I know that I think that there are several important and key provisions in the Citizenship Act of 2021 that will be passed. I just don't think it'll be as one whole bill. I think that it'll be as parts of a bill. Okay, and so what I recommend to anyone who is, you know, sort of exploring the possibility of legalization, or who has consulted and have been told that they, you know, they still have to wait a little more time, or they're not eligible at the moment to legalize, definitely keep yourselves informed, keep yourselves educated about what's happening in immigration law. Our law office, our firm, U.S. Immigration Law Group, our website, we have a resources page. We do our best to present and publish any new and important information or updates in immigration. And so please always think of us as a resource. You can call our office. We're always happy to answer questions. We're always happy to provide information to the extent possible. Be prepared. So even if the Citizenship Act of 2021 has not passed, or even if you've been told that currently there's not an opportunity to legalize, just know that you're going to have to provide essential documents at any point in the future when you can submit applications to CIS. So start taking action. If you haven't consulted, consult. If you have consulted, then you know, start putting your plan together for what you will do to be able to submit applications in the future. What does that mean? It means get your essential documents together. If you don't have a passport, if you don't have a birth certificate, or you lost it, then make an appointment with the consulate. Go to the consulate, get a new birth certificate, get a passport. If you anticipate that you'll have to provide documents to show continuous physical presence, then start getting those documents together. Call your school, you know, your schools or the district that you went to school in to see if you can get attendance records. Call your doctors and see if you can get medical records. Call your dentist and see if you can get dental records. Just get documents that show, again, your physical presence in the US. Don't wait, because sometimes when we wait too long and we contact those offices, either they're not there anymore or those documents have already been purged or destroyed. So don't wait, do so now. Have a plan. If you think that, you know, you would qualify for DACA, but you know, perhaps maybe you didn't finish high school, or maybe you didn't get your GED, then enroll in, you know, night school, get that GED going, get that high school diploma going, because that is going to be how you ensure your future, how you're going to be able to invest in your future. And then also use your voice. Contact your congressional representatives, have your family, have your friends, have your colleagues contact their congressional representatives, and express to them how important it is that they seriously consider passing and voting yes on the Citizenship Act 2021. And I mean, I think in California, our representatives, this is the kind of bill that our representatives would likely be inclined to pass, but I don't know if they would be inclined to pass it in its entirety. So put the pressure on your representatives in Congress, because they're the ones who hold the future of immigration in their hands. And then also, you know, as I said, be educated, ask questions. Always feel free to contact me at U.S. Immigration Law Group. Our phone number is 714-494-4545. We are located in Santa Ana, California, and we are a team of attorneys who are just dedicated to immigration law and helping not only our local community, but our greater community, our national community, and just helping those who need guidance, who need to help navigating the immigration system, because it's very complex and it's very complicated. And so just know that we're here for you. I thank you so much for participating today. I don't see any questions, but let's check again. Yeah, I don't have any questions, but if you finish this presentation and you have questions later on, feel free to email me at mcrooms@usilg.net or give our office a call. And I think with that, I'll go ahead and conclude. I will say, I know today's presentation is in English. We do have some Spanish language presentations in the pipeline, and so we will we'll promote those when they happen. I don't have set dates yet, but we will publish those on Facebook, on our Instagram, and visit us. Feel free to visit us. Visit our Facebook page, U.S. Immigration Law Group. Same with Instagram. We also have Twitter. Please just feel free to connect with us in any way, even if you've never consulted with us before. Just know again that we are a resource to you, to your family, to the community. So please just feel free to reach out. Okay, and I think that is where we'll end today. So thank you very much. Enjoy your Saturday, enjoy your weekend, and thank you again. Just thank you for participating with us today, and thank you for your support. Okay.